us today one of the brightest stars, Professor Dr. S.N. Singh, the Professor of Law and former Dean, Faculty of Law, University of Delhi. Sir, as an administrator with an eye for detail, has been a crusader to uphold standards of legal education at Delhi University, and as a researcher, has contributed immensely to the legal scholarship. He has played an important role in making legal education accessible. For instance, he has made sure that the course material was freely available and was made online. And he also made efforts to bring about certainty in the almanac at traditional law universities, which is otherwise not so. We are extremely privileged, sir, today to have you among us to speak on the topic access to justice and fundamental principles under the Constitution of India. Please extend a warm welcome to sir. Thank you, sir, for accepting our invitation.
Good morning, friends, and I'm really very much delighted to be in your company this morning. My great privilege. And after having known that this galaxy consists of faculty members and research scholars, I don't think that much can be said, except that if you things can be stated by me in my own way, that is the only difference we will make. Otherwise, things are already known to you. There's nothing actually which can be said to be something very innovative. Friends, when we talk about access to justice, and it is very, very catchy word actually, access to justice, everywhere access to justice. Supreme Court is very fond of using this term, access to justice, as a fundamental right. What is this concept, access to justice? Is it access to justice or is it access to courts? Because justice is in the hands of judges. You can approach the court. And what is justice then?
Redressal of one's grievances.
Get an opportunity to get your grievances addressed. But if you don't get the relief that you want, then there is no justice. Can we say that? Fundamentals of the Constitution, the preamble part, the doctrine of basic features, an uncertain doctrine. Nobody knows what is basic feature, only judges know. From time to time they will tell, this is basic feature or this is not basic feature. They will illustrate rule of law, freedom of press, secularism, independence of judiciary, separation of powers, and we do not know how many more items will be added. But basic controversy, which has been engaging every one of us, we in the universities as teachers and as researchers, judges in the courts deciding cases, and the government imposing all kind of political theories and views. All actually overthrown fundamental rights. People today talk about separation of power. Who is bothered? If you talk about independence of judiciary, then judges bother. Everything which hurts them, which is likely to affect them, that takes away independence of judiciary. starting from appointments till after retirement. Not only retirement, after retirement also. So security has to be there, and that providing security is independence of judiciary. But is it really independence of judiciary? You keep on evolving new concepts, keep on interpreting the constitution the way you want. But in the long term, do things can go on like this? Only a couple of days back you have seen that when a lady approaches the court, that several cases have been filed, registered against her, and there is a threat to her life. You know what judges said? You have created the hell. You have made derogatory remarks. Go on TV and apologize publicly. You have apologized with ifs and buts. And then you see the reaction of the masses. Then what happened? She again approaches the court, the same bench yesterday. What does now it says? No, we never wanted to put your life into danger. All right, till 10th August, no arrest. Same judges. What has changed actually? Is there any change in the scenario? Everything same, judges same, the petitioner same, advocate the same. Then why this fundamental change in the view after a couple of days? Only because of public resentment, nothing else. And compare it with the other case, the journalist, he gets protection. Now, on the very first date. Why? Because that was considered by another bench. Actually, when we talk about law, there has to be certainty in law. There has to be predictability in law. But is it now existing? Can you say today that on this point, this is the law? The other day I was talking somewhere and I said that there's a lot of confusion regarding what is meant by life imprisonment. How to decide what is life imprisonment? Earlier things were very clear. They said 14 years. But now what is the position? Look to about half a dozen cases decided in 2019 itself, just 1 year. In one case, life imprisonment means 14 years. Another one, all right, to remain in jail for 20 years. The third one says remain in jail for 25 years. The other one says you remain in jail for 30 years. The other says 35 years. One says 40 years. And then one says till you die. As a teachers, what will you tell the students? What is life imprisonment? I personally cannot say anything. What is life imprisonment? I don't know. It is for the judges to say from time to time. And they don't explain anything. Why 20 years? Why 25 years? Why 30 years? Why 35? I mean, give reasons. Why? After offense has been proved against you, we have all reasonable doubt. That is why you have been convicted. The sentence is life imprisonment. Then why this change? 14 years to 35 years and then till death. Where is predictability? Fundamental rights are given to whom? For whom? Against whom? Only citizens as well as persons. Two words are there. Person word is there. Article 14, for instance. 21, for instance. Can the central government be the petitioner under Article 32? The central government files a writ petition claiming fundamental right under Article 32. Is the petition maintainable? How the court has acted? There was a case. I give you citation. You know the case, only I am just reminding you about the case. Union of India versus Sri Haran. Elias Murugan, 2015. The state of Tamil Nadu wanted to release the convicts in Rajiv Gandhi assassination case prematurely. The central government objected to it. Then what was the permissible course of action? A kind of contradiction in two views, central government versus state government. Then what should have been done? बताइए? Under what provision? That is the question. Which provision? But this is no dispute as such. Where is the dispute? I think that was the ideal solution. 143 could have been invoked. And not only could, it should have been. That is the only perhaps force. I entirely agree with you. But what the Union of India did? It filed a writ petition under Article 32. Read the judgment. It will refresh your memory. 2015, 13, scale 165. Then somebody objected. My lords, the petition is not maintainable. And the court says, after all we have heard the arguments, there is no point actually in throwing away the petition on this technical ground. This is not a technical ground. This goes to the very root of Article 32. And you allow the petition. Question here is, when we talk about access to justice, these are these fundamentals of the Constitution. What is meant by access? You have access, go to the Supreme Court, get a pass prepared, and that will be great difficulty. And enter any courtroom. That is the access. Access to the court. If you have a case, if you have a grievance, then what do you do? How many of us present here can draft a petition for the Supreme Court? I would say perhaps none. No, don't take it in a derogatory. I'm just telling you that highly educated persons with so much qualification, so much expertise, they cannot approach the Supreme Court by filing a petition. Then, even every advocate cannot do it. Because Supreme Court said, no. Everybody cannot file a petition in the court. No, only advocates on record can do it. Advocates on record. Why? Because they are supposed to know about the technicalities, about the procedure. Then where is the access to justice for a common man? What does he know? He will not get even a pass to enter the court premises, not to talk of getting any redressal of his grievances. Then naturally he has to engage advocate. Which advocate? He can't afford Mukul Rohtgi or Kapil Sibbal or Abhimanyu Singhvi because their fee, one day fee goes into lakhs of rupees, 10 lakhs, 50, anything. Amount is not material. Anything can be taken by them. And everything in cash so that no income tax is paid and nobody will know. And if the income tax rate, they say, well, Deemak lag gaya tha, sara kha gaye kagaz. So there also you are out from income tax clutches. So what is this access to justice? Merely saying that every citizen has got freedom to move the court, approach the court for justice. Is it really meaningful? It is just an eyewash, just utopia. Common man has no access to justice. And access to justice in the strict sense of access to the court, I am saying. As far as justice is concerned, that we will talk later. Constitution, particularly fundamental rights, they revolve basically on three grounds, three principles: equality, liberty, freedom. How the courts have tried to interpret these concepts? Take for instance, equality. Article 14, 15, 16, then of course 17 also. The state shall not deny to the person equality before law and equal protection of law within the state of India, throughout the state of India. Okay? That is the type of rule of law which we have. Exception was made. For women, children, special provisions could be made. For backward classes of citizens, special provisions can be made in public services. Backward classes. Provided they are not adequately represented in the services. So whether any backward class of people, they are adequately represented in the service or not, that has to be seen with reference to facts and figures. The data has to be collected. But then where the distortion started? The framers of the Constitution never said that you give reservation to this caste or that caste. No. They say backward classes. What is backward class then? When the cases started pouring in the Supreme Court, the first question was, what is backward class? And what the Supreme Court did? They converted class into caste. That is why the whole distortion of equality class came. It is the Supreme Court which is responsible. And now, no holds are barred now. Everybody can be given this benefit, everybody can be given that benefit. And now you see what is equality now. Almost everywhere. Particularly in educational institutions. How many students are admitted solely on the ground of merit? Either on the basis of their marks in their original examination or on the basis of marks in the index test. How many? What is the percentage? कभी दिया ख्याल किया इसका? If suppose you have got 100 seats, what is the reservation now? SC, ST, OBC, then EWS, then PWD, and there are other
Kashmiri migrants, then
several others are there, armed forces and this and that. हो सकता है कल जो है वो कर्मवीर भी आ जाए, कौन से वीर? अग्निवीर, उनके लिए भी शायद आ जाए. We don't know. Then and number one, number two, if these category persons they are covered by their own merits, then they have not to be adjusted against the reserved seats, and their number is considerable. Then how much remains for the candidates on merits? Not more than 20%, maximum 20%. Is it the equality? Is it what the payments of the Constitution envisaged? And this system is actually percolating further. It is unending actually. It is not stopping at any stage. It keeps going. And how much bitterness it has brought. I could never imagine that there will be associations of teachers and students based on caste. ये SC का है, ऑर्गेनाइजेशन ये SC का है, ये OBC वालों का है, ये EWS वालों का, ये EWS means anybody, because a person who doesn't pay income tax, he EWS.
He must not be.
वो तो ठीक है, उसको वहां मिल रहा है तो यहाँ क्यों आएगा, वो तो दैट्स इम्प्लाइड एक्चुअली. Is it what actually framers of the Constitution envisaged? And is it how things are going to continue? Supreme Court says that reservation is not against merit. I hope you must have seen that. Is it correct? If it is not actually affecting the merit, then why do you have it? Scrap it. Finish. Let everybody come on, because you say that everybody is meritorious. And there is no system that after a person has got the benefit, what next? How long he will continue to get the benefit? Whole life. Unending. Look to the government actions. There was a case from Rajasthan. How equality is being maintained by the government. Umpteen number of cases. You can't count how many cases on equality under Article 14, 15, 16. There was a PIL by an advocate in Rajasthan High Court. And the PIL was that from the Chief Minister's relief fund, compensation is paid to the victims of crimes. He was particularly interested in the victims of rape because in a particular year, there were 392 reported cases of rape. And out of 392, one victim was given compensation of 5 lakhs, another was given 3.95 lakhs, and 13 were given compensation between 10,000 and 50,000. And 377 were not given anything. So the petition was that the Chief Minister's relief fund is being used in a discriminatory manner. After all, victims are victims. Offense is the same. And the victims are illiterate, poor. They have no means actually by which they can approach the court for redressal. The High Court said yes, it allowed the petition, issued certain directions. The matter came to the Supreme Court. In the Supreme Court, what the judges said, Chief Minister holds a high office. And this high office term has been used at least 5 times in the judgment. Is the holding of high office an issue which should sway the court in decision making? The court said, no, your status is not material. But here, the judge is using this term, high office, more than 5 times. And he said, after all, we must believe a person is holding such a high office. It is a dismissed. Now, my question is it justice? Was the issue not actually very relevant? How the courts become so insensitive to such fundamental questions? Equality doesn't mean that a man will be made a woman and vice versa. No, that is not the equality. Equality means that if there are 2 teachers appointed for the same job, they must get equal pay. That is equality. Very good. Yes. That is how it should be. But unfortunately, the manner in which equality is being maintained through judicial process is not the real equality. No rule of law. You have seen every day there are criticisms, and it is said that judges decide cases on the face value of the advocates. To many, in many circumstances, and most of the time I would say, yes, that's correct. If you want immediate relief and you can afford that money, engage a top lawyer and you get the relief. Even if the case is of no use, to get the relief. Recently, you have seen that there was a case from Tripura, a PIL, where a person said that a security given to Mukesh Ambani by the central government is not justified. Why the state should be at expenses for his security? The richest person of the country. And you are providing security? What is the threat? So the High Court of Tripura issued notice. And they say by this day, kindly produce the record about the security threat. अब security threat हो तब तो produce करें record. We need more security than Ambani. And the moment the order was issued by the High Court, the central government came before Supreme Court. बड़े बड़े ताकतों के खड़े हो गए. Government के तो after all there is no dearth of money for the government. And immediately the order was stay. My son filed a case against Mukesh Ambani in a PIL. For months together, it is not being listed. And there is no system by which you can do it. In Mukesh Ambani, that matter, Supreme Court said this is tomorrow, the very next day. What was such urgency actually? Is it the equality? Is it the equality in terms of access to justice? Absolutely nothing. It's just an IVAS. We can only teach in the class. There is rule of law. There is equality before law. There is equal footing of law. But that is only in the books here, not in actual practice. And nobody bothers about actual practice. Freedom. Article 19. Citizens have been given certain freedoms. Right to speak, including freedom of press. How that freedom is being protected by the Supreme Court and by High Courts? In what way? Nupur Sharma case you have seen doesn't require any elaboration, but it is still there in the court. There was a serious allegation against one of the retired judges of the Supreme Court regarding sexual harassment of an intern, law intern. The judge immediately filed a writ petition before Delhi High Court. And the High Court restrained the newspapers and TV channels from publishing any news pertaining to that matter by saying that once the reputation of a judge is harmed, you can't restore it. So therefore, the publicity must stop. Then there was an established. He thought I should also get the same protection. After all, one person has got, so not, why not? After all, there is equality before law. So he also filed a petition. Now the same High Court, of course, different judge. He says, you are a businessman, you are a politician also. You must be ready to face this kind of allegations. No stay. Now, how to justify this kind of approach? In one case, because the person is retired to the Supreme Court, you stay the newspapers and media from publishing anything. And in another case, you say, no, you must face, you must be ready to face this. That was Jindal's case. This was Sutan Kumar's case. There was a case, very interesting case. I thought I must tell you and get your reactions also to that case. That is 2018. There was a magazine published from Kerala. क्या था नाम? Magazine का क्या? What was the name of the magazine? Anyway, name I am also not getting. In that magazine, an article was published with the title Misha. Misha means mustache, mooch. That was the title of the article. In the article, there was a dialogue between two persons which was published. Two persons, they were having their morning walk in the park and they were talking to each other. Then one of them asked the other person, why these girls take bath and put on their best clothes when they go to temple? Why do these girls take baths and go to temples with the best of their clothes? The other person said, naturally for praying to God. No. Then look carefully. Why do they need to put their best clothes in the most beautiful way to pray? Now this is important. They are unconsciously proclaiming that they are ready to enter into sex. What is your reaction? Whether this kind of publication should be allowed or should not be allowed? कोई बताइए?
Should not be allowed.
Is it not highly derogatory? In my article I wrote, what do they do then? What should they do? I agree. Derogatory not only to the girl but to every woman, I say. Why are you confining it only to worshippers? Then my question will be that any girl, any lady who takes bath and wears best clothes, say for marriage, she is going to attend the marriage ceremony. Apply this. Where the court is going actually? In what direction? Now, see what the court says. I'm quoting. The court says, literature symbolizes freedom to express himself in various ways. One should never forget that only when creativity is not choked, it helps the society to be able to accept thoughts and ideas of a free mind. I put one question to judge. I said that when the matter was pending before you, and you had already made up your mind that you are going to make this kind of observation in the judgment, why don't you ask your wife or any female member in your family that this is how I am reacting and I am going to give this kind of judgment and ask for her reaction? What will she say? That will give you a reply, whether your view is correct or it is not correct. But who is bothered about us? Nobody. But this shows how the courts, they have been dealing with the matters. They are not bothered actually. And the judges are Western culture, every Western philosophy. I wrote at one place, I read out from my article, 2-3 sentences. The individual freedom, liberty, gender identity, and right to sex autonomy have superseded both law and religion in this country. Be the penal provisions relating to unnatural sex criminalized as unnatural offences under Section 377, or sex with another person's wife without her husband's consent or connivance, criminalized as adultery under Section 497 of Indian Penal Code. Are the matters of religious faith, such as entry in a temple, or the institutes of marriage itself, or living relationships? How much earlier decisions have swept away by the tidal wave The recent judgments expanding the scope of fundamental rights contained under Articles 14, 15, and 21 of the Constitution can be seen from over half a dozen judgments given by the court recently. And Chief Justice Deepak Mishra proclaimed, this is on account of changing perceptions of the world. The judges in India seem to have either no confidence or lost confidence in the Indian culture, tradition, and philosophy, and they are blindly following or applying the Western culture and philosophy, unmindful of the Indian values and culture, reflected in well-accepted principles and practices tested and followed since infinity. This is what I have said. Some of the judgments should be remembered in this country for the mental perversity of the legal fraternity. This is what I say, this is my view. Judgment should be remembered for the mental perversity of the legal fraternity, not only of the judges and lawyers, but also of academicians, politicians, so-called present-day reformers, and those championing the cause of human rights and individual freedom. Question here is the court really going to upset everything that has been settled till now? That is what seems to be the position. As the government is now doing, everything must be unsettled. Perhaps what was done till now, what interpretation was given till now, that are all accepted, and everything must be replaced. That is how things have come to. Supreme Court has got a very great power to punish a person for contempt of court. You know that contempt of court? कोई चीज आपने लिखा अरे सब contempt हो जाएगा. Some person threatened me also. Oh, your courts are very, very critical. Judges will feel offended. I said, what do I do? I am a retired man. I will spend my life in jail. I have no other work. क्यों डरूं मैं? Yes. And advocates come get contempt of court, you know. Prashant Bhushan. So much human crime. Now he must be punished. Yes. So what was the punishment? 1 rupee fine. A mockery of the whole system. And that 1 rupee was given by Rajiv Dhawan, I was just telling. 1 rupee was given by Rajiv Dhawan in a very mischievous smile. सारा फोटो फाटो लगा के 1 रुपया दे रहे हो, दूसरा ले रहे हो, हंस रहे हैं. I mean, what are you doing really? Why don't you punish properly? If you feel that he is doing something wrong, then punish him. नहीं, punish तो करना चाहिए रुपये. अच्छा, जज की? हाँ, वकील की? अरे भैया, प्रशांत के कम से कम 1 दर्जन तो फ्लैट्स हैं नोएडा में. PIL फाइल करके वो कर जा रहे हैं. They file PIL and then take huge money. I don't want to delve deeper into this matter because I know the reality. There is one advocate who will approach the court every day. अब गवर्नमेंट ने या किसी ने कुछ कहा, लिखे उनका पिटीशन सुप्रीम कोर्ट में. He has the access to justice actually. And Supreme Court says कि रोज आप लेके चले आते हैं, हम लोगों को तो अलग बेंच ही बनाना पड़ेगा. So you were encouraging भाई. Court is encouraging him to do it. I don't know how can they an advocate file a petition every day for everything. Cases are not being taken up. There is pendency of cases, and now PIL. Some 2-3 advocates have actually specialized in this venture. They perhaps feel that by becoming this kind of nuisance element, they will achieve something big. Anyway, so this is one, contempt of court. Then another one, a retired Supreme Court judge. He writes a blog in a magazine. What does he write? That was a case of murder. A person was convicted on the basis of PSA evidence. That was the factual position. Now the judge writes, the statement of PW4 and PW40 bear hearsay evidence. PW4 and PW40 do not say that they themselves saw the so-and-so jumping the wall. And hearsay evidence is inadmissible in evidence by Section 6 of Indian Evidence Act, except in certain limited circumstances. Hearsay evidence is not admissible, exceptions apart. Now then he says, Justice Gogoi, who is in line to become the Chief Justice of India, on the basis of seniority, has shown that he does not know an elementary principle. Justice Gogoi does not know even an elementary principle of law, namely that hearsay evidence is not admissible in law. Even a student knows about it. This is the blog. Was it contemptuous or was it not? Was it a fair comment? Where was the need of saying that so and so will be easy in the line of becoming Chief Justice? You would have said that the court has committed this error. Fine, matter shouldn't there. Why further? And when notice was issued, Justice Kagi said, sorry, I apologize. No, not enough. Apologize in a proper way. Then he apologized. All right, you have apologized. I give an example. You are traveling in a bus. Somebody puts his foot on your foot. And he says, sorry. He didn't do it intentionally because there was rust inside the bus. So somehow his foot actually came on the foot up on the bus. Fine. Matter ends there. But if a person has done it intentionally, कोई भीड़ नहीं कुछ नहीं एक के पांव के ऊपर आपने रख दिया पांव जोर से रख नहीं दिया मार दिया एक तरह से और फिर कहते शादी इज इट पार्डनेबल देन यहाँ दिस जज इज एक्चुअली सेइंग एवरीथिंग intentionally knowing full well the consequences also, but he apologized and court said fine you have apologized. All right, what about Justice Karnan? He also apologized. Court said, no, you are too late now. No apology. You must go behind the bars for 6 months. How do you justify this contradictory approach? Is there really fundamental difference in the factual situation in these cases? Sahara case, yes. Absolutely no uniformity, nothing. The other day, yesterday only, Professor Virendra Kumar and we were just talking. He said the Constitution of India doesn't create any kind of hierarchy among fundamental rights. He spoke here also perhaps on this. The framers of the Constitution never intended to create hierarchy among the fundamental rights. Once I remember there was some LLM question paper, objective type question paper in India, and one question was, which fundamental right is most important? I said, what is this stupid question? What is this question by? So the question is, hierarchy is there or is not there? All right. A plain reading of the Constitution says no hierarchy. There are 6 fundamental rights and 6 are there. Some of them, of course, they have been converted into basic features, some of them not. Now the question is that if there is a clash between 2 rights, somehow there is a clash, then what do you do? I say, if you have no life, fundamental rights have no meaning for you. So therefore, at least life must be there. Fundamental right to life. Only then other rights come in the picture. Now suppose this right conflicts with another right. Take for instance the ban on use of plastics. The manufacturers of plastic, the traders, they are affected, rather their two rights are affected by this kind of ban. One, their own life to live and their life to trade and business. Now, how do you reconcile? If you say that the right to business must be subordinated to right to life, does it amount to creating hierarchy? Where is the question of hierarchy? Perhaps he was discussing with reference to Article 25, subject to so and so, and other fundamental rights. Hierarchy doesn't exist. And therefore, a conciliatory approach has to be adopted. Without going into which fundamental right is more important than the other, how to create them 1, 2, 3, 4, 5, 6. No, don't, what is the need? Why should you go to that? We have only to see whether a particular right should be accepted at the moment or should not be. Now, if plastic use of plastic, manufacture of plastic has been banned, naturally, it is in the interest of life of everybody, including the manufacturers themselves, as well as the environment as a whole. Therefore, without going into the controversy, whether this is actually a superior right than the right to carry on trade and business, I would say let both of them stand in their own way. Whenever there is a need, you interpret that term. Don't decide the hierarchy. There's no need. कि कोई assistant professor, associate professor, professor, vice chancellor की hierarchy नहीं है. There's no need. Why do you do that? Umpteen number of cases, freedom of press. Whether a movie produced by the producer should be banned or not. Whether a book written by an author should be banned or not. The courts have taken virtually a kind of, they have closed their eyes. They have allowed everything. Whether this closing the eye is really good gesture. When there is a kind of agitation, then the courts take one view, like Nupur Sharma case. I can never justify this kind of change in approach of the court in Nupur Sharma case. Within 2 weeks, one view and two views, just contradicted to each other by the same judges in the same facts and circumstances. Really saying that my threat perception has increased after your other way, that's meaningless. That threat perception was always there. So therefore, when we talk about freedom, the courts are not at all consistent. They have been interpreting in their own way. I won't say that they're interpreting at their convenience, but they are interpreting in their own way, unmindful of the consequences. I have said that some of the judgments indicate mental perversity of the legal fraternity, including judges and lawyers, and we also. Because we never actually criticize the cases. We never critically examine the cases, which is our duty. Teachers have the freedom. This is the best class where there is nothing, no punishment. You speak whatever you feel like speaking. So therefore, it is the duty of the teachers, the researchers, to speak the truth, to critically examine every case. Don't go because Supreme Court has said, so my lords, your lordship. No, nothing my lord, my lordships. You analyze in your way and give your own comments. May not be accepted by the board because they don't bother about comments. But then at least for our sake, for our students, we must express ourselves the way we feel like. We say that the judgment doesn't sound very, very good. These are flaws in the judgment. Talking about that offense under section 497 IPC, what the court should be doing? You go seeking one relief, and you go, they get totally different thing. You never asked for it. What was the relief sought in that petition under 497? 497 is adultery. The relief thought was that why only males are punished? Why not females? That was the relief they wanted, there must be equality. And what was the relief? रही बांस बजी बांसुरी बहुत बढ़िया, very good. There's nothing like an offense of adultery. All right, then proceed a little further. Let's say that a woman, married woman, whose marriage success, she has extra affairs with somebody. No contact with the husband. Marriage is still there, but not having any connection with the husband, and she elopes with somebody. And a child is born out of that eloping. Who would be the father of that child?
Husband.
But the fact is that husband is not the father actually. Then what to do? कौन फादर कहेगा भाई हम हमारा नाम मत लेना, मैं फादर नहीं हूँ, वो तो 4 साल से वहां रह रही है मायके में. आई एम नॉट द फादर. Then what is the reply? What the Supreme Court has to say on this? ठीक है, कह दिया कि adultery is not an offense, fine. But what about this issue? Indian evidence act says that father is the husband is the father. But the fact is that husband is not the father. Somebody else is the father. Then how to resolve this controversy? I think the judgment really, I mean, very appealing. That is all right. You say freedom, freedom, freedom. Woman is not a child. Perfectly all right. I don't think that in India people are treating women as chattel. Forget about the offences. Of course, they continue to be there, and they will always continue to be there. They have always been there. But in general, how wife is treated, how a mother is treated, how a sister is treated in India. I'm not talking about forced marriages and muta marriage and all that. I'm talking about true Indian tradition, culture, Hindus, let us say. How do they? My wife left about 4 months back. I'm not able to reconcile till now. That is the kind of relation you have. And now you say, no. So sex is not something which must be confined to husband only. आप कुछ कह रहे थे? हाँ.
Sir, 112 में एक उसका exception भी provided है, non access.
नहीं एक्सेप्शन जरूर प्रोवाइडेड है, लेकिन क्वेश्चन है कोई एक्सेप्शन पे क्यों जा रहे हैं? आप जनरल रूल पे आइए ना. I am applying it in the context of Supreme Court observation. Supreme Court should have seen this also. कहना चाहिए तुमको कुछ कि अगर ऐसी सिचुएशन आती है then what? आपने देखा होगा तिवारी वाले केस में. Incidentally, his mother was not actually married perhaps or divorced or widow something. And that man, of course, वैसे तो ये कहने के साथ कि हमारे फादर तुम हो और कहता नहीं मैं तुम्हारा फादर नहीं, तो बड़ा अजीब सा इंडियन सिस्टम में. I mean, this is unthinkable to be very frank. लेकिन खैर बेचारे उसने अपना ढाढ़स बढ़ाया, गया कोर्ट, वहां पे कहा जबरदस्ती से डीएनए टेस्ट कराओ, ये करो वो करो, दुनिया भर का.
There are two kinds of issues that crop up with adultery, sir. Whether it should be treated as a criminal offense or whether it should be merely within the civil law purview. So I think the approach of the Supreme Court was more that जो भी करना है आप एक दूसरे से कर लो. Why are you invoking criminal offense in this context? Agar if one of the partners to the marriage is indulging in adultery, then you have a recourse in the form of divorce, judicial separation, and other personal law remedies.
कोर्ट ने यही कहा है, कोर्ट ने यही कहा है. लेकिन आप इसे देखिए ना, टोटल एंड पर्सपेक्टिव ऑफ इंडियन कंटेक्स्ट में देखिए आप इसको जो है इंग्लैंड और अमेरिका के कंटेक्स्ट में मत देखिए. इंडियन के कंटेक्स्ट में अगर कोई आदमी आप मान लीजिए कोई सम वुमन, her husband is actually having this kind of affair, will she be able to tolerate? Will she have actually a normal life in the family? पूरा फैमिली बर्बाद हो जाता है. आप सोच के देखिए इस बात को, चाहे वुमन अडल्ट्री में हो चाहे माइनर अडल्ट्री में हो, any one of them.
There was another kind of inequality that husband was not like, was indulging in some activity, he could not be prosecuted.
It was another point.
मेरा सिर्फ कहने का मतलब ये था कि इसके कॉन्सिक्वेंसेस और थोड़ा आगे बढ़ के भी देखिए ना।
Nationality law करे तो succession laws के साथ भी कर सकते हैं। जैसे 2005 में उन्होंने women को co-parts में बना दिया, daughter of a co-parts।
नहीं, जहाँ पे डिस्ट्रैक्शन से दे नीड टू बी करेक्टेड।
सोचा ही नहीं कि जो फाइलिंग ऑफ केसेस हुए अब तक कोई वो सेटल नहीं कर पा रहे, उस 2005 अमेंडमेंट को जस्टिफाई नहीं कर पा रहे। इसकी बजाय तो वो करते मिताक्षरा को दया धागा सिस्टम लेके एक यूनिफॉर्मिटी लाने के लिए बोलते हैं, you know that there is no classification like that, ठीक है, a person is an independent owner of his property. वो 2005
That could have been better. That could have been better. Yeah. Now, when we talk about access to justice again, actually the whole program is on access to justice, isn't it? Let us see who has access to justice. One is that person who has means to do it. Okay? पैसा है जिसके पास resources हैं. He has access. And I say again same, access doesn't mean access to court, not justice. Justice is separate, which we will discuss later. Who else has got access to court or access to justice? One, that we have got CPC, we have CRPC, we have Consumer Protection Act, we have Constitutional of India, so many. They provide access to justice, access to courts. But some persons, some category of persons, they have more access than others. What is that category? Some category of persons, they are put better off, in a better position, much higher pedestal than others. And here, I would say two categories. For whom special laws have been made? SC, ST. For them, the law is already there. If something happens to you, something has been done against you by a non-SC, then this is the consequence. First, you get compensation and the rest things come. The offender will not get even bail. Fine. Second category, for whom special provisions have now been made, women. Domestic violence, for instance. Now the question here is, when these special category of persons have been given more access, I would say, this is my framing of the term, more access, what is the consequence? SC, SC, Atrocities Act, 498A and read with Domestic Violence Act. Where have we reached actually by this access?
Destruction of family.
बताइए.
Kind of establishing equalities. So they do not have a.
जेंडर न्यूट्रल नहीं है ये लॉ, जेंडर न्यूट्रल होना चाहिए.
As far as this is concerned,
But
every
we need to
applicant.
understand the reason why there is a special law in the first place. The socio-economic condition of these vulnerable sections have always made sure that they stand outside the entire system of access to justice. Now, for them to even understand that they have rights, that there is a rights base.
All right, accepted. The question is, how did it actually help them? And in what way do you protect those against whom this access to justice has been provided? Well, that is an important issue. I will talk about the protection given to the victims. Which law provides them the protection? What kind of protection? But later on. So now the question is that if you have given access to vulnerable sections, women or SC, ST, then what next? Has their position changed? Because you say everybody should have access to justice. So now these persons have got access to justice. What is the consequence? Where do they stand now? Has their position changed? No. And what about those against whom this access has been provided? Where do they stand? In substance, my question is, what has been the consequence of these special provisions? Where do they stand now? Even now, Supreme Court has started saying there's great misuse of Article Section 498A and Domestic Violence Act. The parents, the brother, the father, anywhere living in the whole country or even abroad, they are actually clubbed in the case and then they are tortured actually. So is this access to justice actually justified? And how many women? I think each one of you must be knowing at least one or two cases where a woman files a petition or a suit, a criminal case under 498A and Domestic Violence Act, just to squeeze money. There is no final decision in the case. Ultimately, होते compromise. अच्छा ऐसा compromise consent divorce by consent mutual consent हो गया. अच्छा ऐसा इतने पैसे दे दो. And matter ends. कहाँ गया वो? ऑफेंस तो हुआ था, तो ऑफेंस खत्म हो गया. By giving money, the offense has been you have been exonerated of the offense.
But that is the problem of the administrative of justice.
No, not administrative. No. That is one aspect. The question is that these provisions, this access to justice is being misused. That is the whole problem. How do you actually have a regulatory framework by which you ensure that there is no injustice? Nobody is victimized unnecessarily. How do you ensure that?
Sir, as far as every law has been. So the basis of the law. So the basis of law cannot be questioned.
No. My question. Let me tell you one thing. Have you seen the SC Atrocity Act? Prevention of Atrocity Act? क्या है उसमें? What is the crime actually? मैं आपको एक एग्जांपल देता हूँ. If some non-SC or non-ST forcefully garland shoes to ASC or ST, जबरदस्ती जूते की माला पहना दिया, सिर घुटा दिया, SC के घर के सामने कूड़ा फेंक दिया, like that. ये तो बहुत कॉमन एग्जांपल मैं बता रहा हूँ जो उसमें लिखे हुए हैं. तो माय क्वेश्चन इज कि भाई अगर मेरा से कोई जबरदस्ती घुटा दे तो हमें भी तो राइट हो चाहिए, हमें नहीं चाहिए क्या? भाई ऑफेंस क्या है? ऑफेंस एक आपने जबरदस्ती किसी का सिर उड़ा दिया, यही तो है ना ऑफेंस. किसने किया, किसका किया, वो बात की बात है. बट इट इज एन ऑफेंसिव थिंग फॉर एनीबॉडी. भाई हम इतने बड़े बड़े कंकी कर रहे हैं, वो आपने हमें जबरदस्ती हमारा गर्दन पकड़ा और उठा के हमारा सारा घोड़ दिया, या हमारे गले में आपने माला डाल दिया उसकी जूतों की. भाई क्यों हमारे गले में माला डालने? अगर SC के गले में माला डालने पे ऑफेंस बन रहा है तो हमारे लिए भी वही करेगा. माला डालना जूतों का तो बुरा सबके लिए है. कूड़ा आपने हमारे घर के सामने फेंक दिया, कचरा, तो इट दिस इज ऑफेंसिव टू एवरीबॉडी. व्हाई ओनली SC?
It was not because the mindset of the blacks. They deserve Kura. So that's why they deserve some people committed.
No, question is, don't go too far behind. Not too much ancient. The question is now we are talking today. Where do we stand today?
Have not been allowed to.
Semi-urban and a rural setup, you see that these caste-based
Madam, have you seen those reports in which a Brahmin or a Kshatriya or a Vaishya has been forced to drink urine by SC people? Have you seen that? एक नहीं कई ऐसे हैं आपको बताएं, लेकिन उनके लिए ऑफेंस नहीं है. वो क्या करेंगे आप? तो SC के लिए भी है, IPC के लिए है भाई. My only question is whether this access to justice जिसके बारे में इतना हुआ बनता है, everybody should have access to, all right, everybody. But when you are giving excessive access to justice, then what is the consequence? And has it improved things? यही तो आप कह रहे हैं एक्सेस जस्टिस से होता है जिससे सबको जस्टिस मिले, यही तो है ना कंसेप्ट. तो इसमें क्या जस्टिस मिल रही है क्या? कहाँ डिफरेंस है? और डिफरेंस तक जा कहाँ रही बात? वही आपसे पहले कहा, 3 केसेस में कन्विक्शन क्या है? हाउ मच कन्विक्शन रेट इज देयर? आपने एक FIR दर्ज करा दिया, साहब हमारे घर पे हमारी मिसेज के साथ ये बदतमीजी कर गया ये ठाकुर, और फटाक से उसको जो है FIR दर्ज हो गई और उसको इतना उसमें लिखा हुआ कंपेंसेशन की चार्ट बना हुआ, आपने देखा होगा, ये लो कंपेंसेशन. तो कंपेंसेशन सुप्रीम कोर्ट के जजमेंट्स हैं where they say that for getting compensation there are complaints. So how do you ensure that this kind of misuse is not there? And what has been the course reaction?
Is Supreme Court, does Supreme Court has any data before saying that?
No, there is no data. No, I am also not talking about data. I am only talking about general remarks. But my question is, I am asking data from you. Tell me, under 498A or Domestic Violence Act or SCS Act, how many convictions do you have?
Sir, एक question, एक मतलब ऐसे,
Sure.
I understand. सर एक बात बताइए, अगर
जी।
किसी चीज का पोटेंशियल मिसयूज होगा, क्या मतलब उस एरिया पे, और या फिर कोई पर्टिकुलर मिसचीफ करने के लिए अगर हमें कोई लॉ बनाना पड़े, तो क्या हमें फ्रेम करना चाहिए इसलिए कि वो उसका पोटेंशियली मिसयूज करे?
मैंने मिसयूज की तो बात ही नहीं करा। मैं तो ये करा हूं कि उसके कॉन्सिक्वेंस क्या हुआ। एक्सेस टू जस्टिस जो आपने दिया, वाकई जस्टिस हो गई क्या? Have you achieved that objective? My question is this one. Huh?
It is failure of the state.
So then how do you rectify the whole situation there?
Not end merely at enacting laws. There has to be institutions and executive mechanism that has to go hand in hand with the special law that is being.
Ma'am, the difficulty is you commit any kind of crime, if you have political part on it, then there is no crime. आप देख लीजिए, हकीकत में जो लोग जो है हीनियस क्राइम्स कर रहे हैं, आपको पता है शाहजहांपुर में रेप की लड़की का रेप किया साधु ने, अल्टीमेटली उसके परिवार को मारा, किसको मार मुर के खत्म कर दिया, कल कुछ नहीं हो गया। तो क्वेश्चन ये नहीं है, क्वेश्चन हमारा बड़ा फंडामेंटल है। क्वेश्चन ये है कि वेदर दिस एक्सेस टू जस्टिस इज रियली मीनिंगफुल फॉर एनीबॉडी, आई वुड से। वो तो मैंने पहले क्वेश्चन मार्क लगा दिया कि अगर आपके पास मीन्स है तो आपको एक्सेस टू कोर्ट है, अदरवाइज तो एक्सेस का कंसेप्ट वही से खत्म हो गया। दूसरा है कि जब आपने स्पेशल लॉज बनाए हुए हैं कुछ कैटेगरीज के लिए, तो वहां पे क्या ऑब्जेक्टिव जो है सेटिस्फाई हो रहा है, क्या अचीव हो रहा है कि नहीं हो रहा है? और नहीं हो रहा है, देन व्हाट हैज बीन द रोल ऑफ द कोर्ट्स देन? अगर आपको कोर्ट को ये पता चलता है किसी केस में सब फॉल्सली जो है रिलेटिव्स हैव बीन इम्प्लिकेटेड, देन merely saying that नहीं एफआईआर हम क्वेश्चन करते, नो क्वेश्चन क्यों करना है आप? देन यू पेनलाइज द पर्सन हु हैज बीन फॉल्सली इम्प्लिकेटेड, क्यों नहीं करते आप? उससे जो है जो डिटरेंट आएगा, जेन्युइन केसेस ही आएंगे। एंड देन विक्टिम्स, आई रिमेंबर केस, आई हैड गॉन टू माय विलेज अबाउट 3 years बैक, तो पता चला कि देयर वाज वन मुशहरा Sidhu tribe family. The family had a girl and she eloped with a boy near वहाँ कैनाल था उसके पास, वहां पे दोनों पकड़े गए। लड़का तो भाग गया, लेकिन फैमिली वालों ने उस लड़की को मार डाला, अपनी लड़की को मार करके वहीं पे फोड़ के दबा दिया। और लोगों को कह दिया if anybody states about this to anybody, yeah, inform the police, then same fate will be met by him also. रिजल्ट ये हुआ, कुछ नहीं, वो लड़की गई, चली गई, कुछ नहीं, वो कोई क्राइम नहीं, कुछ नहीं। Now the question is, when we are talking about the victims, how do we really protect the victims so that at the same time they do not misuse? Victims sometimes are not actually victims. They are the offenders. This is the case. If some false complaints have been lodged by a person, he is not actually victim. He is victimizing somebody. How do you take care of this kind of situation? How the courts have reacted? I had asked one question before the judges. I delivered a lecture once before Allahabad High Court, and I posed this very question. That we have got so many laws. We have got innumerable number of judgments. We have got number of NGOs, human rights organizations. You can't count. Only government might have the data. How many of them are actually bothered about the victims' rights? Everybody is talking. This man has been a set, but और पड़े प्रशांति भूषण लोग कौन फलाना ढमका सब लोग, और आप बताओ इसको देखो पुलिस देखो इसको टार्चर कर रही है, पुलिस देखो इसको तुरंत बेल दिलाइए, और he must have legal. If all the rights are only for that accused, what about victim? Article 20, 21, 22 of the Constitution क्या है? ये आर्टिकल्स क्या है? A person who has been arrested must be put on before the nearest magistrate within 24 hours, must be given legal representation, he cannot remain in custody beyond 24 hours without the order of the magistrate. He must be told about the grounds of arrest. किसको मिला ये बेनिफिट? अक्यूज को. बाद में प्रूव हो गई वो बात है, लेकिन इमीडिएटली तो विक्टिम को तो कुछ नहीं ना. What is enough for victims?
These laws aim to look at it, there's always an accused pitted against the mighty state. So in that case, we need to make laws.
No, but why only against mighty state? Why not against another poor person?
Administration of justice, it will be accused that is pitted against the state, not the other party.
So in every crime there are three parties: accused, victim, and state. You are talking about accused and the state, but what about the victim? Accused sufferer is the victim. What about them? Which law provides them protection? Which human rights organization talks about the victim's right? प्रशांत भूषण के कई केस विक्टिम का केस लड़ रहे, उनके पास टाइम ही नहीं होगा, मिलेंगे ही नहीं वो, तो उससे कोई फायदा नहीं है. People are not bothered. कोई भी आप क्रिमिनल केस देख लीजिए, whether a person has been injured, whether a person has been killed, whether a person has been tortured, हर जगह पे ज्यादा से ज्यादा क्या होगा? एक आदमी मरा, अगर 2 लाख रुपया कंपनसेशन. एक नया सोचा बन गया आजकल, पॉपुलिस्ट अप्रोच ऑफ द गवर्नमेंट. दौड़ो दौड़ो दौड़ो, ये 2 लाख रुपया दे दो. You remember in Delhi, there was a couple of years back, there was a murder of a girl, Mochi की लड़की थी, मीनाक्षी. She was killed in daylight by a neighbor. Then the Kejriwal government, populist government, notorious government, I would say, they went to the house of the victim and they said 5 lakh compensation will be given. I remember about 2 years before that, there was one person who had died at Jantar Mandir, who had come in the demonstration which was held out by Aam Aadmi Party, Gajendra Singh Chauhan. He was paid 20 lakhs by our government. और यहाँ पे 5 लाख. अच्छा, थोड़े दिन one day I was coming from the High Court. I thought, let me see what is this case. What was the problem? How this girl was killed. तो साहब वो गली में जाते जाते ढूंढते ढूंढते घर मिल गया उसका घर. ये नहीं था कैसे हुआ, क्या हुआ? तो मैंने कहा कुछ गवर्नमेंट से कंपनसेशन मिला? Then the father of the girl said, नहीं साहब 5 लाख रुपया काटे गए थे, अभी तक तो मिला नहीं कुछ भी. I do not know how it came to my mind. I immediately filed a PIL in the High Court in my own name. That this is how the girl was killed and she was promised somewhere, not even a single penny has been paid. Immediately notice was issued by the High Court. And Kejriwal had to pay 10 lakhs immediately. अब क्वेश्चन ये आया, हम अपने बहादुरी की बात नहीं कर रहे थे, it was just incidentally that I happened to be there. अगर नहीं कोई करता वहां तो क्या विक्टिम को क्या मिला, उसके फैमिली क्या मिला? शी वाज ओनली, मतलब थोड़ा बहुत काम करके कमाती थी. मोची था वो, उसका फादर और मदर टोटली इलिटरेट. How do we actually justify this kind of approach? So neither in terms of right to equality, neither in terms of right to freedom, we have got any predictability in the judicial approach. The courts have not been taken and deciding cases by laying down fundamental principles which are to govern at least identical cases. I remember I was in the Supreme Court one day in the court of Justice Lalit, and he was dealing with a case of compensation for land acquisition by the state government of Gujarat. So he said his compensation has to be increased. So he ordered the increase in the compensation amount Then the advocate for the petitioner, he contended that my lord, actually, by the same notification, the land of a number of other landowners has been taken away, and they also must be given relief instead of dragging them to the court. And then he cited 3-4 cases also. That is how the courts have been doing it. They have said that if there are identical cases, why should everybody be dragged to the court? Already there is pendency of cases, so much areas are there. Do you know what the judge said? No. They have their own rights and remedies. Let them invoke their own remedies. No relief. Recently, Supreme Court, same bench, decided another case. That was the case of pension for Delhi University teachers. The arguments were concluded on 25th November 2020, and judgment was given on 10th May 2022, after 1.5 years. And that was the last day of one of the judges who was retiring on that day from that bench. So, majboori mein diya. Same problem, many persons had come to the court, hundreds of petitions were there. So they said, no, teachers must be given the pension. Then he made another observation, and nobody had asked for it. Because I was in the court, I was very much a party to the whole thing. Then he made all other teachers who have not actually opted, they must be given an opportunity. How do you justify this approach? They have not come. And compare it with the Gujarat case. What was the difference there? There at least a person is asking for it. Here without asking you are giving. You are passing an order, and that opened Pandora box. Where is the consistency? Article 142, for instance. Full and complete justice. What is this full and complete justice? Nobody knows. There was a case where a person, an employee, had challenged the terms and conditions of his appointment. These days, there is a lot of practice of employing people on ad hoc basis. 4 महीने 6 महीने इस तरह से हर जगह चल रहा है, यूनिवर्सिटीज में, गवर्नमेंट में, हर जगह. So that was the case from Bihar. And he said after appointment, after some time, he challenged the terms and conditions. Now what happens? Number one, that these persons who are appointed on ad hoc basis, they do more work than the permanent teachers and employees. क्योंकि जो काम ना हो इनको पकड़ा दो, यही होता है ना. अच्छा, उनका सब्जेक्ट तो कोई नहीं पढ़ा रहा, उनको दे दो. This is a practical aspect. They don't have, if female teachers are female employees, no maternity leave, no medical leave, no leave at all, except casual leave.
तो यूनिवर्सिटी के 2 एड हॉक टीचर्स बैठे हैं, अब तो परमानेंट हो गए हम दोनों. हम रहे हैं एड हॉक दिल्ली यूनिवर्सिटी में 4-4, 5-5 साल सर.
कब की बात है ये?
तो मैं रही 13 से 16 तक सर.
अच्छा, 13 से 16.
सर दोस्त चल रहे वहाँ पे.
11, 17.
तो थोड़ा दिन और टॉलरेट करते तो वो परमानेंट हो जाते. क्योंकि उसके बाद वो हाई कोर्ट का ऑर्डर मिल जाएगा ना, दिल्ली हाई कोर्ट में 126 लोगों का अपॉइंटमेंट हुआ. दैट वाज इन माय पीआईएल. अभी भी पोस्टें तो निकली हैं. नहीं, वैसे मैं नहीं कहूँगा छोड़ के जाओ, लेकिन दिल्ली वैकेंसी तो शायद अभी भी आई हुई है सर.
यहाँ शादी होगी, हम यही आ.
अच्छा, फिर तो ठीक है, फिर तो वंडरफुल, कांग्रेचुलेशंस. हाँ, क्या कह रहा था मैं?
About the decision, Gujarat High Court.
No, that was already over. Something else I was telling about. So one employee actually went to the court saying that the terms and conditions are arbitrary and discriminatory. And the matter came to the Supreme Court. And the Supreme Court says, you accepted the terms and conditions voluntarily, nobody imposed it on you. Once you have accepted it, you can't challenge it. I asked one question. What is the challenge? Challenge is arbitrariness. And you know, arbitrariness is a facet of equality under Article 14. Okay? Now, the court just brushed aside. In one sentence, you have already accepted. After accepting, you can't challenge. Now, my question was that when you accept an appointment of any nature, whether ad hoc or contractual or anything, do you have any bargaining power? आप ये कहिए साहब ऐसा है, हमको तो तनख्वाह वही दीजिए जो परमानेंट को आप दे रहे हैं, और इंक्रीमेंट भी आपको हर साल मिलता रहना चाहिए. तो कहेगा रास्ता देखो, यू डोंट डिजर्व टू बी। अरे भाई तो न्यूसेंस हो जाएगी, इनको तो पॉइंट करने का मतलब ये कि न्यूसेंस। बट द फैक्ट रिमेन्स that the term and condition is arbitrary. And Supreme Court in many cases they have said that even if you are appointing a person on ad hoc basis, the minimum of the scale you have to give. Delhi University में है. Minimum of the scale you have to give. Don't give increment, all right, but minimum of the, not that कि साहब ये 20,000 रुपया ले लो, not 20,000 नहीं चलेगा, not fix the amount. You give the scale, the minimum of the scale, and along with all the allowances. So what was the fault of that employee when he went to the court? But no. Then I said that can fundamental rights be waived? Is there any concept of waiver? No, no waiver. And in Gupta Swamy case, the Supreme Court once again has reiterated this rule. And recently now, in another case, the Supreme Court says that a person, even after accepting terms conditions of service, he can always challenge for violation of any of his rights, including fundamental rights. So where is the consistency actually? Inconsistency is there only because one bench decides one way, another bench decides another. And if you look to the judgments, 1400 pages, 1500 pages, 1600 pages, आप देखिए ना बड़े बड़े जजमेंट जो आए हैं सारे, प्राइवेसी का ले लीजिए, सबसे पहला तो वही है। चाहे उसमें जजमेंट्स को पढ़िए आप, देखिएगा, वैसे तो पढ़े नहीं जाते, इट इज नॉट वर्थ रीडिंग। लेकिन अगर आपने टाइम निकाल ही लिया कई घंटे का, कई दिन का, तो उसमें क्या मिलेगा आपको? आपको compilation of all judgments in India, particularly if there are judgments given by the same judge who is writing the judgment, then those extracts will get. इंटरनेशनल कन्वेंशन सारे आपको मिल जाएंगे, जितने भी कहीं उससे रिलेटेड होगा सब कुछ मिल जाएगा, यहाँ तक कि फिल्मी गाने भी मिल जाएंगे आपको। Then on the case, right to life includes right to die with dignity. ये सुना कंसेप्ट, राइट टू डाई विद डिग्निटी। लिविंग विल, गिविंग योर लाइफ टाइम, यू कैन राइट ए विल, हाउ यू विल डाई। ठीक है। और वहां पे एक फिल्म का गाना कोटेड है एक जजमेंट में। कौन सा गाना? इसको पढ़िए ना, तो बहुत इंटरेस्टिंग चीजें हैं जानने।
शॉन पार्क में भी बिगनिंग में शेर लिखा हुआ जज।
नहीं वो उसमें नहीं, शेर के बाद थोड़ा फिल्मी गाना। शेर में तो फिर भी ये होता है कि आदमी फिर भी कुछ सोच समझ के ही लिखता है, फिल्मी गाना लिखा हुआ है। मुकद्दर का सिकंदर, रोता हुआ आया है हंसता हुआ जाएगा। रोता हुआ आया हंसता हुआ जाएगा। मैं पूछता हूँ, कोई मरते तो मैं हंसता हुआ जाता है क्या? उसको हंसी आएगी क्या? उसको होश होता है कि हंसू के रो? What is this kind of decision making? मैंने कहा एक जजमेंट आपका 1500 पेज का लिख दिया, इसमें कम से कम 20 जजमेंट लिख देते आप। आप जो इतना बड़ा कंपाइलेशन पोथा बना दिए हैं, इसी जगह पे आप 20 जजमेंट छोटे छोटे 20-20 पेज का लिख देते। नहीं वो नहीं करना, क्योंकि तो हीरो बन जाना है। एंड नोबडी बॉदर्स अबाउट द जजमेंट नाउ। जैसे जैसे रिटायर हुए काम खत्म, वो जजमेंट कोई बस बादर नहीं करता, बादर करने लायक है भी नहीं। हाँ नहीं, और नहीं यही नहीं, जहाँ पे एक्चुअली ठीक जजमेंट देना चाहिए वहाँ 2 पेज का जजमेंट आता है, 1 पेज 2 पेज। और अगर आपने सुप्रीम कोर्ट की कभी हियरिंग देखा हो, एज ए स्टूडेंट रहे हो, कभी विजिट किया हो, तो वहां जाइए, देखिए मंडे और फ्राइडे मिसलेनियस डेज, आउटकेशन आर टेकन अप, आइटम 1, और आइटम 1 में अभी वकील साहब खड़े भी नहीं हुए, डिसमिस। तो पता चला साहब वकील साहब के जो है बड़े वाले मोटे तगड़े वाले वकील है, माय लॉर्ड, ऑलराइट, फिर फाइल आई, डिसमिस होने के बाद फिर ऑलराइट नोटिस। ये होता है, दिस इज एक्सेप्टेड जस्टिस। मर्डर के केस में 2 पेज का ऑर्डर, मैं ले आऊँ, जानो नहीं कल उनको बताऊंगा मैं, 2 पेज का ऑर्डर। We are remanding the case to the High Court for consideration as far as the quantum of punishment is concerned. The aggravating and mitigating circumstances have not been considered. However, we make it clear, but one thing, however, we make it clear that we are not disturbing the conviction of the accused. और ये सेंटेंस 2 बार आया 2.5 पेज के जजमेंट में। 2.5 पेज को अगर सिंगल स्पेस में आप उसको टाइप करेंगे तो 1 पेज में ही आ जाएगा, वैसे 2.5 पेज में है वो। और इस सेंटेंस को उस ऑर्डर में, उस जजमेंट में 2 बार कहा। However, we make it clear that we are not disturbing the conviction of the accused. We are remanding the case for considering the aggravating and mitigating circumstances because the accused was sentenced to death, which has been converted by the High Court to life imprisonment without indicating the aggravating and mitigating circumstances. आप पढ़िए, I do not know what kind of words should be used by the persons who are not actually affected by judgment. How should we react actually this kind of judgment? By the apex court. Then we have got so much of power. Court has got so much of power to review. Then curative petitions. Somebody asked through an RTI application about disposal of review applications. What happens in review applications? Review petitions are decided by the same judges who have decided the case unless they have retired. Clear? And these review petitions are not actually considered in the open court chamber में होता है। फाइल चली गई होगी, पड़ी रहेगी 10-15 दिन, उसके बाद डिसमिस हो गया तुम्हारा। वो कंसिडर हुआ भी नहीं हुआ, क्या हुआ, nobody knows. So this is how the power is exercised. लेकिन अगर करना हो, वाकई करना हो, रिव्यू करना हो, 377 Section 377 IPC. One then says, this is perfectly all right. Unnatural says, not permissible. It's an offense. उसके बाद बड़े बड़े मोटे वकीलों ने पूरा जिहाद छेड़ दिया। तब तक इसको क्वेश्चन नहीं करा लेंगे, तब तक दम नहीं देंगे। तो हमने एक चिट्ठी लिखा चीफ जस्टिस को, what is this kind of threat this man is issuing? Salve had said this. जब तक ये खत्म नहीं कर देते 377 को, तब तक चैन नहीं लेंगे। तो मैंने कहा किसी से थ्रेट है, कंटेम्प्ट है। तो वहां से चिट्ठी नहीं, कोई कंटेम्प्ट नहीं, आप चाहें तो रेगुलर अपना केस फाइल करिए। मैंने मुझे क्या पड़ी, एक बजे केस फाइल करो, केस फाइल करोगे तो निकलेगा क्या? इतना प्रेशर बना दिया कि वो केस रिव्यू किया और जजमेंट को ओवरटर्न किया। ये है रिव्यू का। अदरवाइज मोर देन 90% केसेस review petitions are dismissed without changing the judgment. Number one. Number two, in 10% of cases where the judgments are changed, it is only because the judge has changed. Same judge नहीं करते। स्टैंडिंग काउंसिल पे उतना नहीं डिपेंड करता, जितना डिपेंड करता है जजेस पे। अगर वो बदल गए, चले गए हैं, तो उनके व्यूज को आराम से वो चेंज कर देंगे। अदरवाइज नो। In some of the death penalty cases, I will tell you tomorrow how the courts have actually reacted actually. In what way they have conducted cases. Extreme penalty, death. And you are treating the cases in a casual manner. This is the justice. Now comes the third one. And along with that, the right to religious freedom. A lot of things are being said about religious freedom. Entry into temple, then triple talaq, then of course one more case is there that violated in the Supreme Court. What is the extent of this freedom? And how restrictions, what kind of restrictions can be imposed? Subject to morality, public order. You know, what is morality? When the Constitution was made, when it was written, what could have been the concept of morality in the mind of the framers of the Constitution? And please remember, morality not in a general sense, morality vis-a-vis religion. क्या कंसेप्ट हो सकता है? धर्म के सिलसिले में मॉरल वैल्यूज का क्या मतलब हो सकता है? and particularly Indian context, because we are talking about India, we are talking about America or England, we are talking about India. In India, religion, morality. Code says morality means constitutional morality. What is this constitutional morality? ये कहाँ से आ गया भाई? What is this concept of constitutional morality?
It is before the advent of the constitution.
Was it a correct interpretation really? And constitutional morality means all fundamental rights. So this freedom of religion is subject to all fundamental rights, constitutional right to equality, right to non-discrimination, I mean all those things. I would say this is not actually the correct interpretation. Morality cannot be interpreted in the sense of a constitutional morality. It has necessarily to be interpreted in the traditional manner. Number one, at the time of framing of the constitution, there was no concept of constitutional morality as such. Number two, it is a morality with a reference to religion. It's not in general. Then, in these matters, the courts have again taken a very, I would say, inconsistent approach. Remember, there is a practice known as Santhara.
Yes, sir.
किस religion में?
Jainism.
Jains में. What does it mean? What is Santhara?
Starving unto death.
Starving to death. ठीक है? A petition was filed in Rajasthan High Court. And Rajasthan High Court delivered very detailed regional judgments, saying that Santhara is not a practice which is related to religion of Jains. It's extra. And therefore, the court directed that any person who indulges or who instigates somebody to go for Santhara must be prosecuted. An appeal was filed in the Supreme Court. It is about 7-8 years back. When the matter was conducted by the Supreme Court says, while deciding, this is important actually, while deciding the case, the High Court did not consult religious people from Jain religion. धर्म गुरुओं को नहीं कंसल्ट किया. The judgment was stayed. और उस स्टे के बाद within less than a year, a girl aged 16 years, she died by Santhara. और उसका बड़ा प्रोपेगेट करते हैं उसको, मतलब बहुत हाईलाइट करते हैं. आपने देखा होगा जुलूस निकालते हैं. ये तो हुआ एक अप्रोच. The judgment is still, I mean the case is still pending. Nobody is bothered कब आएगा क्या आएगा नहीं पता है. लेकिन चूंकि religious पीस को आपने कंसल्ट नहीं किया और जजमेंट दे दिया, तो आपका जो है जजमेंट सही नहीं है. What about divorce, talaq? What about entry in Sabrimala temple? मुस्लिम रिलीजन, हिंदू रिलीजन, वहां भी तो आपने किसी ने कंसल्ट किया. किसी धर्मगुरु को बुलाया आपने, किसी मौलवी को बुलाया कि आप बताइए साहब आपको क्या करना है, और फटाफट आपने डिसाइड कर दिया. मतलब दिस इज द करेक्ट अप्रोच. How do we analyze actually these cases? I am talking about the process by which decision is made. I'm not talking about the merits for the time being. I'm talking about the process. Whether consultation should be there or should not be there. And if it has to be there, then it must be consistently done for all. But the court is not doing it. Then what is the remedy? In what way you are bringing about equality and right to religious freedom at par? कुछ नहीं कर सकते. वही every time one has to say, now whatever charm we had in law, predictability and certainty, that is gradually disappearing. Now the judgments are being delivered as if they are purely subjective. Personal satisfaction, yes. You don't have objectivity. Therefore, you can't say whether the court will take this view or it will take this view. No, no consistency there. Well settled principles, they have been unsettled. Now, the third aspect that I had said, they talked about liberty, personal liberty. And personal liberty, as you already know so much, it is an umbrella which is spread over the entire horizon. Everything is part of right to life. कोई चीज आप बोलिए, that is part of life. यही तो है ना इंटरप्रिटेशन आज की डेट में. And therefore, if according to what Professor Viren Kumar says, if gradation is to be done, then I would say then right to life must be at the number one position. True, because if number one position is not there, 2, 3, 4, 5, 6 don't exist. How the courts have reacted to right to life? In numerous ways. But my concern is about actual right to life, right to live. Jinda रहना. How the courts have reacted to this right? Not that supplementary rights. The basic rights to live. Maneka Gandhi, so many cases. Fair procedure should be there. Just procedure should be there. Reasonable procedure must be there. Then one fundamental right that doesn't exclude. So if you justify it under Article 21, they must can also justify under 19 and 14 separately. Now, there was a case from Chhattisgarh. The case was that the accused had raped a mentally retarded girl and he was prosecuted and acquitted by the trial court. The state filed appeal in the High Court and the High Court also acquitted the accused. Then the matter came in the Supreme Court. In the Supreme Court, the court found that nobody is representing the accused. There is no advocate for him. So the court appointed one amicus, a lady. And in the judgment, it is written that she has helped a lot in this case. That amicus who was appointed has helped a lot. So an appreciation certificate was also issued. The accused was sentenced to 7 years imprisonment and fine of 5,000 rupees. After about 8 months, the same case again came before the same bench. I don't know what was found. It was found that the accused had died 3 years back. 3 साल पहले मर चुका है accused. और amicus ने इतना बढ़िया आर्गुमेंट किया. How do you justify this kind of decision making? ना स्टेट काउंसिल को पता है, ना एमिकस को पता है, किसी को पता नहीं कि जिंदा भी है कि नहीं है. और कन्विक्ट हो गए वो. And the judge has no even courtesy to say that we feel very sorry. In fact, the court should have taken action against the amicus. आप क्या आर्गुमेंट कर रहे हैं भाई? क्या आपने ऐसा कौन सा मदद किया आपने? आपको जब यही नहीं पता है कि क्यों मर चुका 3 साल पहले, तो आप आर्गुमेंट क्या कर रही हैं? That shows how eyewash process is followed, even at the apex court. This is one. There was a case from Maharashtra. There was a guava orchard. It was given on rent to somebody. And the tenant actually constructed a jhogi in the same place. and he started living with the family. One night, after they had taken their food in the night, they were just gossiping. And few persons from outside came. They barged inside the juggi and they brutally beat the people who were there. Both mara. Two, one lady and one girl, they were dragged out of the juggi and they were raped. And the brutality was to this extent that 5 persons died. The matter was reported to the police. Police investigated the matter. There was identification parade. And 6 persons they were prosecuted. 6. The lower court convicted all of them and sentenced to death. Then there was an appeal. You know that reference is made in their cases to the High Court for confirmation. So the matter went to the High Court and the accused persons also filed appeal against the conviction. So in the High Court upheld the conviction of 3 persons for and sentenced to death. And for other 3 persons, they upheld the conviction, but they said that no death sentence, life imprisonment. So 3 got life imprisonment and 3 death sentence. Then there was again appeal and before the Supreme Court. Now in the Supreme Court, the matter was heard by a bench of 2 judges, Justice Pasayat and M.K. Sharma. One day argument took place and the case was adjourned by about 2 weeks. Second time when the case came up, then the judges realized that nobody is representing 3 accused persons. 3 जो थे, 3 का तो एक वकील था, लेकिन और जो 3 बचे उनका कोई वकील नहीं था, जबकि आधा आर्गुमेंट हो चुका एक दिन, उस समय नहीं नोटिस में आया. Now then the court said that 3 persons are not represented. So the judges said, ask that वकील जो आगे 3 का कर रहा था उसे पूछा, can you argue for them also, remaining 3 also? Yes my lord, yes my lord. देखिए कैसे अपॉइंटमेंट्स होते हैं, आर्गुमेंट्स होते हैं. सुनिए, दिस इज वेरी इंपॉर्टेंट. कैन यू डू इट? यस माय लॉर्ड. अच्छा सुनाइए. हो गया, कहानी बन गई, आर्गुमेंट्स हो गए, जजमेंट रिजल्ट हो गया. देखिए ऑन द स्पॉट एडवोकेट अपॉइंट हो रहा है, ऑन द स्पॉट आर्गुमेंट हो रहे हैं, ऑन द स्पॉट जजमेंट रिजल्ट हो रहा है. अक्यूज क्या है, उनका क्या कहना है, एडवोकेट हैज नो कनेक्शन विद देम. एंड द बेंच अवॉर्डेड डेथ सेंटेंस टू ऑल 6. ठीक है, हो गया. Then 2 review petitions were filed. One was by 3 persons and the other was by 3 persons. One of the review petitions came before the same very bench. वही मैं कह रहा था ना कि 90% केसेस में पिटिशन डिसमिस किए जाते हैं अगर जजेस वही हो. जजेस बदल जाए तो शायद थोड़ी पॉसिबिलिटी होती है शायद जजमेंट बदले. So now this judgment actually was put for review before the same bench by 3 accused persons and the review petition were dismissed. Incidentally, the other review petition did not come before them and they retired. कभी कभी लग देखिए कितना, कहाँ तो फांसी हो गई होती बेचारों को, लेकिन बाई चांस वो रिटायर हो गए and the matter kept pending. In the meantime, Supreme Court decided a case in which the Supreme Court said that in case of death sentence, review petition shall be considered in the open court. बहस होगी उसको open court में, वो चैम्बर वाला नहीं होगा सर्कुलेशन से. Open court and the review petition shall be heard by 3 judges bench. Matter was placed before bench of 3 judges. Now these 3 judges, they say that these accused persons, they did not get fair opportunity of representation before the first bench. So therefore the matter must be considered in open court. Then the matter was placed before another bench and it was put before the court. Now the court says that the evidence of eyewitness was not taken by the police during investigation. These persons who have been convicted, they are not the actual persons who have done the crime. None of them. These persons, they had been behind the bars for 16 years. 16 साल हो गए थे जेल में तब तक. And one of them was a minor at the time of committing the crime. He also remained with them, 16 saal, minor को 16 saal. And for quite some time, because they had already been convicted for, sentenced to death, so they were confined in solitary confinement. अकेले कर देते हैं ना कुछ दिन के, फांसी होने से पहले. So the court found that proper investigation was not done, and all these 6 persons, they are not guilty, they were acquitted honorably. The state was directed to compensate them by giving 5 lakhs to each of them, and state was directed to take disciplinary action against those police officers who investigated matter initially if they are still in service. Nobody knows, because 15 years had passed, so nobody knows whether they were still in service or not. And the matter should be reinvestigated. Now tell me, how will you react to this kind of decision making? क्या हुआ होगा? Think of the situation.
What is the
No, that is right. But the question is, who is guilty then? भाई ये तो फैक्ट है 5 लोग मर गए, ये फैक्ट है 2 लेडीज का वहां पर रेप हुआ, ये फैक्ट है एट्रोसिटीज का भी, then who are the accused persons?
was the real victim?
Who? Not victim. Victim तो मर गए भाई.
Sir, आपके इसमें अगर जिन्हें falsely indicate किया गया,
हाँ.
they have been victim of-
They, exactly. The alleged victims, they are actually not the victims. They have been victimized. They themselves become victims actually. They are not the offenders. No, but my question is whether this is how the cases have to be decided by the court. मतलब in death sentence cases, matters are taken so casually. How do you justify it? How anybody will justify it? Anyway, my friend says that perhaps we have to stop here today. We will continue tomorrow. Yeah, we will continue tomorrow. हाँ, क्वेश्चन खूब नोट डाउन करिएगा. जैसे हमें भी कोई ना है, देखो नेशनल यूनिवर्सिटी के टीचर्स ने जो है वो ठीक से नहीं हमारा लेक्चर सुना, क्योंकि हम जब एलएम के स्टूडेंट थे तो हमारे टीचर पूछते थे, जो स्टूडेंट पढ़ाते थे वो, तो क्लास के बाद पूछे कुछ किसी को पूछना है तो कोई पूछे तो हमसे कहे कि तुम कुछ पूछो, नहीं सब क्लियर है. क्लियर इसलिए था मुझे कुछ समझ ही नहीं आता था क्या पढ़ाते हैं. थैंक यू.
Thank you, sir.